In this video, we're talking about some common defenses to domestic violence charges in Arizona. Our office, we do criminal law, and we see a lot of people come through with domestic violence cases. And so over the course of many years, these are some of the most common and best defenses we've seen play out in court. And so let's run through them. As a quick reminder, domestic violence by itself is not a crime in Arizona. It's actually a designator that they'll tack on to other crimes. So if somebody's charged with an assault and that assault happened within the confines of a domestic relationship, it will be assault/domestic violence or disorderly conduct/domestic violence. So when you're considering defenses, you always are going to want to start with the underlying offense. What are some defenses to assault or disorderly conduct or criminal trespass? Then there are other defenses that we see as applied to domestic situations as well. So we'll run through those and it will include both of them, but this is more geared towards domestic violence charges. So first and foremost, most domestic cases that we see come through are misdemeanors, and they involve arguments, which is disorderly conduct, or they involve assault where there's some sort of touching. And so one of the big defenses is that really the conduct that is being criminalized here is mutual. Both parties were yelling at each other. Both parties were pushing each other. Somebody ripped the phone out of their hands. That's where the incidental contact was. Or somebody was really defending themselves. Somebody was being attacked, and in that defense of themselves by pushing somebody away or holding somebody back, there was some incidental contact. So this is really something that happens a lot, and you can make a good defense on that. You can say, look, I wasn't the person who was actually yelling. They were yelling, and the neighbors caught wind of the argument. They showed up because I'm the male, I got arrested. It happens all the time. And so you want to look at that first. Was there mutual conduct or mutual combat, or was there self-defense? Was the actual incidental conduct or contact as a result of self-defense? That may be a very good defense. The other thing you want to look at is what's called witness availability. So who called the police? Who called 911? Was it a neighbor? Was it somebody who was 300 feet away? Or was it somebody who was standing right next to them and saw the actual incident? And so you want to look at some of those things. You want to see how far away was the witness? What was their proximity to all of the events that are in question? Are they making any presumptions about what happened? So some people just tend to see an argument and they think that something bad is happening, where really it may be kind of minor. You know, people argue that doesn't necessarily equate to domestic violence. So are they presuming that these things happen? Do they have a history in their lives of domestic violence, meaning they are kind of predisposed? They have these presumptions about domestic violence that aren't really based in reality. Do they have any opinions on it? What was their line of sight? But really more importantly, what's their availability? Are they going to come to court? Are they going to take several months of their life to follow the case along? Are they going to be, wanting to get into court and testify and take the stand and point the fingers? I mean, most people really don't want to do that. They call the police because they're scared. They don't know what else to do. But after a couple weeks, couple months go by, they've moved on. They're not really interested in prosecuting anybody. They don't want to be involved in it. They've got their own lives to lead. And so if they're not available, that can make the government's case a bit difficult. Kind of the same story with the victim. So a lot of situations will happen where one person will call the police on somebody else. They want the police to come and help them, meaning they don't expect anybody to be arrested. They just are scared. They don't know what to do. They act out of fear. They act out of kind of impulse. Little do they know that when the police show up, they're probably arresting somebody. And so once that person's arrested, then the person who called 911 says, well, that was totally exaggerated. There was no need to do any of that. They recognize that they may have actually contributed to the situation. They probably shouldn't have called 911, that the whole thing probably could have been resolved, and now it's very complicated. And so they want to start pulling back. They don't want to be involved in the prosecution anymore. They want the whole thing to go away. They feel like it was all blown out of proportion, and in many cases it is. And so what if that victim, the person who was the alleged recipient of the assault or who was being yelled at or whatever the situation is, what if they don't want to be involved anymore? Again, that usually makes the government's case pretty hard. Most of the time in domestic violence cases, the key witness in the whole case is going to be the victim of the crime. The police show up generally after the fact, so they don't witness anything firsthand. They don't actually see an assault. They don't actually hear the argument. They show up after it's already happened. And the only person who can testify to what actually happened is either the person being arrested, who's certainly not going to incriminate themselves, we would never allow that to happen, or the victim. And if there's nobody else who can kind of recreate the conduct, then the police can't go into court, or the government has no witnesses to go into court to testify against the person who's being charged. There's rules that are called hearsay, there's rules of evidence. This can get a little bit complicated when it comes to admissions and what's called corpus, the body of the crime. So you're certainly going to want to speak with a lawyer and have your case properly evaluated prior to just believing that they're going to dismiss your case because the victim won't show up to trial. That's kind of a common misnomer, but it is important. It is something to consider. If the victim is not around and they're not willing to prosecute, that makes the government's case a lot more difficult. They probably don't want you to know that, but I'm telling you. So that's a big part of the case. You want to make sure that you're reviewing that part of it as well. You also want to assess the relationship. So let's talk about the actual relationship itself. Is this something that's a healthy relationship? Was this a one-off incident? Is this something where there's kind of a repeated history of these types of calls? And in some situations, we've had clients who have been charged with domestic violence. But when you start kind of exposing the relationship, peeling back the layers, and you look at the interactions between the person who was charged and the alleged victim, the victim actually has a lot more culpability than anybody realizes. The person who got arrested that one night as a result of one incident. But in reality, they're sort of the actual victim of this whole relationship. And so we've pulled text messages and phone calls and had recorded conversations and all these different things that really show that the victim is kind of manipulating the government. They're actually calling the police. They are instigating the whole situation. They are really the root cause of the problem. Now, a lot of prosecutors don't like that. They don't want you to victim shame. So they don't want you to shift all the blame from the person who was arrested back over to the victim. So if you go into the prosecutor's office and say, well, the victim did X, Y, and Z, and she's a terrible person, he's a bad guy, whatever, they'll just tell you that doesn't have anything to do with the case because the person who was arrested for this reason. But if you can sort of flesh all of this out and get that in front of a prosecutor, it really may help your case in terms of negotiating a plea deal or reducing the charges down from something serious to something a lot less serious, because they understand that these things have a lot more to them than what may have happened on one particular incident. So you certainly don't want to be victim shaming, but if you can help put the relationship in context, that may help. You want to look at calls. You want to look at the person's character. Do they have a criminal record? Do they have anything in their background that they've got a history of domestic violence or a history of filing false reports? Or, there's a whole number of things that you can look into. So these are some of the main defenses. As I said at the beginning of the video, there are also defenses to the underlying assault or to the trespass or to the disorderly conduct. And so you want to look at those defenses as well. But just for the purposes of domestic violence, these are some of the things that we see frequently, some of the things that have a lot of success in and throughout the courtroom. And so if you have been charged with a domestic violence case, you want to speak about some of these defenses as they apply to you or many others, give us a call. We offer free case evaluations. We'll have you come in, we'll sit down, we'll review your case and make sure you have a good plan. Look forward to speaking with you soon. Thanks for watching.